Good morning, ladies and gentlemen. Thank you. In this session, as you see, that we are going to deal with ancillary legislation to support international arbitration. And we are fortunate to have a panel from different jurisdictions. Very important Asian jurisdiction, including the host country, as well as somebody from London. Yesterday we were asking during our Q&A session, we were talking about Halliburton. I understand our speaker, Mr. Rees, is going to bring us some news. Now, I would propose to give a brief introduction to the speakers. Of course, I'll just pick and choose because the distinguished career and experience is too much to go through. The first speaker will be Ko Shu Ying, a Singapore lawyer. Many of you would know her. She is the partner in the firm of Wong Partnership. And again, I abstract a little bit about her relevance to international arbitration. She is the vice chair of IBA, Arbitration Committee. She is also the vice chair of IPPA, Dispute Resolution and Arbitration Committee, and so forth, so forth. Now, she is going to talk about Singapore perspective on the subject. Quite interestingly, she will also say something about the recent interim measure arrangement between China and Hong Kong. That seems to be a big news in Hong Kong, but I'm wondering what is the relevance to Singapore in the Singapore context, and she would tell us. Mr. Havin Rees, QC, again, I'll extract only a little bit. He is from the chambers in London, at 3 Verulam buildings. Of course, you can more or less anticipate the experience he must have had with regard to international arbitration and in the litigation. He is called to the bar of 6 different jurisdictions. He's a fellow of CIARB and been appointed as arbitrator in various institutions like ICC, LCIA, LMAA. Oh, LMAA, very close to my heart. As I said in the beginning, Mr. Rees is going to tell us something about Halliburton. So with many other things like the Brexit, I'm even bored. Outside of London, I'm bored of the subject. But now at least there's a conclusion. So I like to hear what is going to happen. Appeal is and Mr. Rees is going to talk about the appeal to build up common law. I see that your slides cover quite a bit on that subject. And interestingly, Singapore is looking at that route as well, I understand. And also the future developments with regard to the 1996 Act of UK. And then follow will be our third speaker, Mr. Lempo Leung. He is heading the International and Domestic Arbitration Department of the firm of Scholing and Bock in KL. And he is going to talk about the Arbitration Act, Malaysia Arbitration Act 2005, which I know something about it, but then I certainly would not know the 2 amendments that follow in 2011 and 2018. And that would be very interesting to note, as Malaysia is also a very important arbitral seat when it comes to Asia. And the fourth speaker will be from India, Mr. Prashant Kumar. And again, let me see. Prashant is, again, the very, you see a whole page with 2 sides being filled. So again, I'm going to cut it very short. And he's practicing Indian lawyer involved in a lot of international arbitrations, as distinguished lawyers often do, both important cases, enforcement and challenges and so forth. And very interesting and relevant to me, he is also leading the initiative to create a dispute resolution for Brics. For people of you who doesn't know what Brics is, it stands for Brazil, Russia, India, China, South Africa, the 5 emergent economies which form a bloc, and of course, if they are going to have a lot of commercial activities between them, the disputes would inevitably follow. And I understand Mr. Kumar is going to tell us something about it. And also, of course, the amendments to the Arbitration Act in India, the 2015 one, with regard to the challenge of awards, challenge to the awards and interim measures. And interestingly, we also touched the subject earlier yesterday, that India, the attempt to establish a commercial court and bringing arbitration-related disputes under its purview. And there is also the subject of Supreme Court with regarding to allow foreign lawyers and foreign arbitrators and counsel to fly in and fly out, apparently to deal with Indian seated arbitration. So last but not least, which I will feel is entirely appropriate, it is from the host country here in Bangkok. Mr. Saurabh Vasajsit is an ex-judge for close to 10 years. Of course, at the far end of my left, he has been a lawyer he has been a judge for close to 10 years, and now currently he is a lawyer, Rajantan in Thailand as the managing director. He is going to talk about some of the topic which has already been discussed. Firstly, the Thailand Arbitration Act 2002 and the areas to watch out under the Thailand arbitration, such as visa and so forth, for foreign arbitrators and foreign lawyers. Now with that, I think I'm going to sit and listen myself and only come back at the end, if we still have time, say 5 to 10 minutes, so that I can open the floor for Q&A. And at that time, I'll try to come back if overrun, which I hope not, because Q&A is always interesting. Then with that, I may invite the first speaker, please.
Thank you, Philip, for that very kind introduction. I'm delighted to be here in Bangkok. I am going to speak about ancillary legislation to support international arbitration from the Singapore perspective. Before I go into the pro-arbitration regime in Singapore, what I actually wanted to touch on was what is stated in the synopsis. So when I look at the synopsis of this particular session, the ancillary legislation and the sort of focus of the synopsis was actually on not so much the substantive law that supports a particular jurisdiction as a seat of arbitration, but the other incentives that are available to support arbitration and to support the choice of a jurisdiction as a seat. So one of the things that was discussed in the synopsis was actually taxes. And I should say that this is one particular aspect which maybe some may not know, but in Singapore, you are actually exempt from taxes when you derive income for work done in arbitration. And also not just that, there's also a work pass exemption, so you don't actually have to get an employment work pass to be able to practice arbitration, whether as a lawyer or arbitrator in Singapore, and you can do it up to 90 calendar days in a year. And also, the market is quite a free market when it comes to arbitration. Foreign lawyers, which means that you don't have to be qualified, don't have to be a Singapore qualified lawyer. Foreign lawyers are all able to practice arbitration in Singapore. And I think these are the sort of sometimes things which we forget, which actually makes a jurisdiction a very attractive place and a very popular seat. So why is it that Singapore has, in a sense, established itself as the most popular seat for arbitration in Asia, according to the most recent survey? And I think a lot of it, putting aside its neutrality, its location, the infrastructure, the good hearing venue, just generally strong infrastructure that supports the arbitration regime, we have very strong substantive law that also supports arbitration. There are many laws that we can speak about, but I just want to touch on two main ones. The main one that I wanted to touch on is this point, which is a review of negative jurisdictional rulings by arbitrary tribunals. If you are familiar with the model law, we would know that the model law seeks to have a uniform set of rules in arbitrary jurisdictions. Under Article 16.3 of the model law, there's actually review by the courts of positive jurisdictional rulings, but not negative jurisdictional rulings, and that is the position under the model law. What Singapore has done is Singapore has specifically enacted a provision in its Arbitration Act where even if a tribunal finds that it does not have jurisdiction to hear the dispute, that ruling can be the subject of a challenge before the Singapore court. So one would see that you can challenge both positive as well as negative jurisdictional ruling. This actually is a very important consideration for the client when the client decides where to sit the arbitration. Other jurisdictions which also allow this negative jurisdictional challenge includes England and France, New Zealand, I think India as well as Switzerland. Interestingly, Hong Kong does not actually allow the challenge against a negative jurisdictional ruling. And I think this is a factor, or this might be something which not many parties or clients are aware about. The next one that I want to speak of is actually the subpoena to produce documents in aid of arbitration. In most legislation, model law jurisdiction, you will see provisions where they actually allow the courts to issue subpoena against third parties to produce documents in aid of arbitration. This is critical because an arbitrary tribunal does not have jurisdiction or power to make orders against third parties generally. So what this enables the courts to do is to actually issue orders of court compelling a third party to produce documents in aid of an international arbitration, and the international arbitration which is seated in Singapore. I have cited a case in which this precise order was actually made by the court. The court, after hearing the parties, finding that the documents were relevant and material to the arbitration, ordered EY, an accounting firm, to produce all the internal working papers, drafts of its audit that was conducted on the particular casino, because the main contention in this particular investment treaty arbitration case was the confiscatory taxes that was imposed by the government and whether that audit that was done by EY was properly done. So they couldn't, and the tribunal could not make an order against EY, and eventually I acted for the investor in this case, and we managed to get a subpoena against EY to produce these documents. And that, I think, is yet another reason, and if you look at it, the jurisprudence and the decision is yet another reason why people would say Singapore courts are pro-arbitration and they would issue measures without being overly intrusive, but what they are doing is, in essence, trying to support international arbitration. What I would also speak about is proposed amendments to Singapore International Arbitration Act. Our former Minister of Law, Minister Shanmugam, has always said that the Singapore legislature would move very swiftly to make the necessary amendments in order to support international arbitration. And that has always been the case. So for instance, there was the talk about third-party funding between Singapore, Hong Kong. I think Hong Kong first started talking about it, but Singapore was the first to implement and to actually legislate for it. At this point in time, Singapore is yet again considering various amendments to the Singapore International Arbitration Act. In the interest of time, I put on the PowerPoint slides 4 particular amendments. But the one that I really want to focus on is the fourth one, and it is allowing a party to the arbitral proceedings to appeal to the High Court on a question of law arising out of an award made in the proceedings, provided parties have agreed to opt in. This is a particular provision that is not found, obviously, in the common law, but is found in the UK Arbitration Act, Section 69. So the reason why Singapore has started considering this particular amendment is because of the increasing criticism against international arbitration, in the sense that there is a lack of users' confidence in the awards if there are questions of law that is wrong in the award. Because of the finality of an arbitral award, there's actually no further recourse. And when there's no further recourse, what parties tend to do is to fashion it in such a way that they try to put forward a procedural justice challenge, which at the end of the day is really a challenge on the merits. And so the question then becomes for the Singapore legislature, should we not give parties the autonomy to opt into a system where if they want to appeal on a question of law, we would allow them to do so? So it is not an imposed regime by the Singapore courts, but it's an opt-in regime. And at the end of the day, this also addresses some of the comments that's been made by some of the judges in England as to how the development of commercial law, because of the increasing use of international arbitration, is actually to a certain extent inhibited because the arbitral awards are all confidential. So again, allowing this appeal on a question of law would promote the body of commercial law and would also promote certainty in the development of law. So this is something that is under public consultation. With the last 2 minutes that I have, I want to touch on mainland China's interim measure for Hong Kong seated arbitration. Philip asked a very pertinent question at the start. He said, how is this relevant to Singapore as a seat for international arbitration? I think the reason why it becomes relevant to Singapore as a seat of international arbitration is the question of whether, by this particular interim measure, it would enhance the popularity of Hong Kong as a seat. I should first touch on what is this measure about. In essence, this measure states that the PRC courts would grant interim measures, meaning things like freezing injunction, interlocutory injunction, preservation of property injunctions, and other interlocutory injunctions. They will grant such interim measures in aid of proceedings if they are seated in Hong Kong and they are administered by 6 qualified Hong Kong arbitral institutions, any one of the 6. Any one of the 6 would include the HKIAC as well as CTAC, amongst others. So in the past, there never used to be this provision. So in the past, there was never an interim measure which you obtain from an emergency arbitrator, which you could actually enforce in China against a Chinese parties. You could enforce a final award because of the New York Convention, and China is a party to the New York Convention. But the difficulty with not just China, but many of the jurisdictions in ASEAN is that if you obtain an emergency arbitrator award, it may not be enforceable in that particular jurisdiction. And that is the case for Vietnam. I believe that's the case for Thailand. I believe that is also the case for China. And with this arrangement that has come in place, what then it happens is that the PRC courts will then be able to grant the interim measures in aid of arbitral proceedings that are seated in Hong Kong. So that then means that the interim measures would become enforceable against the Chinese parties. So some people have called this a game changer. Some people have said, because of this, then increasingly, if you have a dispute with the Chinese parties and you would want, and you are looking at the possibility of having to take out an application for an interim measure, you would then sit it in Hong Kong, because then you'll be able to get such relief and it'll be enforceable. And this is the interim relief before the final award. Where some people say, well, in fact, it is a game changer the other way around. If you are acting for a Chinese party, which Hong Kong used to attract a lot of Chinese-related arbitration, and a lot of Chinese parties would seat their arbitration in Hong Kong. But some people say it's a game changer the other way, because now, if you're advising a PRC entity, you would be telling them don't sit it in Hong Kong. Because if you sit it in Hong Kong, you run the risk, potentially, of interim measures being made against you, which then become enforceable. So that's the relevance of this particular topic. I see that my time is up. I'll hand it over to Heaven.
Thank you, Sui. Forgive me if I stand up, because otherwise I won't be able to see the slides that I've prepared. Well, thank you very much for the opportunity to speak to you this morning. I'm going to be speaking about the United Kingdom in terms of the Arbitration Act, which is obviously the current act is in 1996. But England has a long history of supporting arbitration in legislation. And I was amazed when I was researching this topic to discover that the first Arbitration Act in England was passed in 1689. So it's over 320 years ago. I mean, it's astonishing, really. And it was written by the famous philosopher and political theorist John Locke, who at the time was at the Board of Trade, and he hated lawyers. And that's why he wrote the Arbitration Act of 1689. Because if you think back to the originality, or the origins of arbitration, it really is based in trade and commerce. So be people bringing in goods into the Port of London, there'd be questions about the quality of the goods, and they'd go to an arbitrator who'd have an expert in that particular field, and he'd decide, or she would decide, whether or not it was merchantable quality or not. So there were no lawyers involved, really, in arbitration in the 1680s. And so that's why John Locke wrote the first ever act. And it was designed to make sure that an arbitral award was immediately recognized as a court order, and so you could then issue a contempt proceedings and imprison a person if they failed to pay the arbitration award. So that's all the way back to the 1680s. I'm not going to take you through all of the acts since 1680 to 1996, you'll be pleased to hear. But the current law is the Arbitration Act of 1996, which is a well-known act, and I'll take you through a few of the provisions of it in due course. But London remains a popular seat for arbitration. In terms of internationally, I think it is the most popular, followed by Paris, then Singapore, Hong Kong, Geneva, and New York. But there's huge competition within the market. Now, I didn't want to mention Brexit, but somebody yesterday told me, so you must mention Brexit. What is happening with Brexit in terms of international arbitration? Now, I was initially going to put in the picture of Edvard Munch, the scream, because that's what Britain has been about in the last 3 years, screaming about Brexit. Thankfully, we've had an election, and so that's going to resolve itself, we hope. But there's been a huge amount of debate within the arbitration community as to what is Brexit going to implicate on arbitration. And there was this survey by Queen Mary University in London, which went into all aspects of Brexit and how it would impact on arbitration. And they came to the conclusion it would be unaffected, which is good news. But it's not a surprising conclusion when you think about it, because Brexit is a completely separate issue to arbitration. And London will still remain a very popular place to arbitrate because the key attractions are unaffected by Brexit. You still have the same judges, you still have their impartiality, neutrality, you'll still have the supported legislation of the Arbitration Act. But we're not complacent, and there are obviously issues to be dealt with in the coming years on Brexit, but I don't think there's any need for anyone to panic that London will all of a sudden be somehow affected by Brexit. So the Arbitration Act of 1996, the key point to understand is it's very supportive of arbitration. The Lord Chief Justice described it as follows: it has maximum support, minimum interference. That's the idea behind the Arbitration Act. And another senior judge has described it really as a relay race, in that if at the beginning of an arbitration dispute, the parties can't reach agreement on who to appoint as arbitrator, for example, then they have to go to the court to decide that point. But then the baton is handed back to the arbitration process by the judge, and the arbitration process proceeds. And the court is only there ever to be supportive of arbitration in England. And so if, for example, you then become embroiled in another dispute about challenging an arbitrator, again, that can go before the English court, but they then again hand back the baton in the relay race as matters progress. And then finally, of course, in terms of enforcement of any award, the court may be brought in at that point. But essentially, the English court steps back and wants to support arbitration and allow it to continue unhindered. One issue under the Arbitration Act, which Sui touched on, is Section 69 of the Act. It's a very limited scope of appeal in an arbitration. And in England, under Section 69, there are probably, at best, 50 appeals to the commercial court every year. And when you consider the huge number of arbitrations happening in London, that's a tiny figure. And of those that are successful, it's within about the number of 5 to 8 a year, which again is tiny. And those who read those judgments would all agree, well, that was an obvious need for an appeal, absolutely. There was procedural unfairness there, or whatever. But it's very difficult to appeal an arbitration award in London through the courts. And this has led to some debate from the same Lord Chief Justice, Lord Thomas of Cwmgyrdd, which I always like to mention that name because I'm the few people from Wales who can actually pronounce his name, Lord Thomas of Cwmgyrdd. You know, I think he did it on purpose to, as a tongue twister to all those English barristers who appeared in front of him. And his comment was, because there are so few appeals from arbitration, it's actually retarded the public understanding of the law and public debate over its implications or its application. So what he means by that is, if everyone is going to arbitrate, the decisions are made by the arbitrators. Well, actually, nobody knows what's happening because it's all confidential. And so the common law of England and Wales, he argues, has been somehow hindered by virtue of everyone going to arbitration. And that's been a point that he's been making for the last 3 years. And so there is an argument to say that the appeal process should be widened. But I have to say, that's an argument which is not readily accepted by the arbitration community in London. And so there's a debate ongoing on that, but I don't think there will be a likely reform of the Arbitration Act for that. But if one considers particular disputes, like construction disputes and maritime disputes, well, the vast majority of those go to arbitration. And so there is perhaps a better argument to say that there should be at least some understanding of how the arbitrators are coming to their conclusions in those cases so that precedents can be formed. But it's a tricky point because obviously we have to respect confidentiality. But in terms of the Lord Chief Justice's remarks of retarding the common law, in my view, what's called the river of the common law is still moving fast. The commercial court in London is very busy. The Court of Appeal in London is stacked full of cases. We've got a 2-year backlog of cases. So there's quite a lot of law, frankly. And so one would think that the development of English law should not be affected. Now, the question of challenging arbitrators under the Act, it's rarely successful. But there's one Privy Council case in 2018, which is worthy of note. But the big case is the case of Halliburton, which Philip was mentioning at the beginning. Now, that went to the Court of Appeal about 15 months ago, and it was in front of the Supreme Court on the 12th of November of last year. And we're awaiting the outcome of the Supreme Court decision. But it's a very big decision, and will have a big impact on the arbitration community, well, particularly in London. And I would suggest wider than that. And if you look if I just tell you briefly about the facts of Halliburton, it arises out of the Deepwater Horizon oil rig disaster in the Gulf of Mexico. BP were ordered to pay 47 billion pounds by way of damages in that case. And Halliburton was found to be contributory at fault. And so they were only found to be 3% at fault, but that's still a lot of money when you're talking about 47 billion pounds. And so they sought to arbitrate that with their insurer. And the chairman of the arbitral panel had already been involved with 2 other arbitrations arising out of the Deepwater Horizon oil disaster, but failed to disclose that to the Halliburton party. And so they challenged that on the ground of bias. It went in front of Mr. Justice Popplewell in the Commercial Court. He said he didn't think there was any argument on bias. He was a very well-respected arbitrator, and this is part of the arbitral process. It's quite a narrow point. Only a few arbitrators can really deal with this level of dispute, and so the challenge was not upheld. It went to the Court of Appeal. The Court of Appeal says, well, he really should have disclosed, but stepping back, no fair-minded observer would say there was obvious bias in this case. And so it's now gone to the Supreme Court. And the Chartered Institute of Arbitrators, the LCIA, and the ICC all petitioned the Supreme Court to be a party to the proceedings because they wanted to make representations. But each of them made different representations to the Supreme Court. So it'll be interesting to hear how the Supreme Court resolves this in terms of whether they are going to make very clear guidelines on how arbitrators must disclose certain things and set out the categories and the likes, or whether or not they're going to say overlapping cases, there'll be some restriction on the appointment of an arbitrator. It's a tricky area, and we await with great interest, I think, what the Supreme Court's going to say about that. Now, in England, we've been going through a consultation by the Law Commission as to whether or not there's a need to amend the Arbitration Act. We say that the 1996 Act is fit for purpose. It's a very good act. It's been very well accepted by the community of the arbitrators and the arbitral community generally. But the Law Commission proposed some reforms, and these are, as I set out on the screen, one is to have explicit provision for summary judgment or strikeout, because there's a sense that arbitrators just allow the process to go, even if there's a weak case or a weak defense, because they're concerned about the risk on enforcement in due course of their award. And the point of the Law Commission in England and Wales is, well, arbitrators should have more confidence. They should be more bullish, because the cost consequences of the other side of having to defend a hopeless claim or the other way around is significant. And so there should be a provision for summary judgment. Also to reduce the length of arbitration, reduce the cost of arbitration. But currently there are no fixed dates for reform, and that's because of Brexit. Everyone's been talking about Brexit in England and nothing else. But I think there is a likelihood of a reform in due course, with many of those issues being adopted, because there is a trend for reform internationally. So, we see that in India, they reformed their Arbitration Act in 2015, Russia 2016, Sweden in 2018. Everyone in the international community for arbitration are desperate to keep up and to maintain the momentum. Thank you very much indeed.
Good morning, ladies and gentlemen. As I've been introduced, I'm going to speak about Malaysia, the Malaysian perspective. Before I move on to that, perhaps I'm sure many of you have known Malaysia, and I think most of you will probably be more familiar with Kuala Lumpur than anywhere else in Malaysia. Essentially, Malaysia, there are 13 states, 11 states in what we call as the West Malaysia, 2 states, which are Sabah and Sarawak, which we call as East Malaysia. The reason I say this because there's certain significance in it, in the materials that what I'm going to discuss later on. Now, essentially, Malaysia has, arbitration in Malaysia is based on the Arbitration Act 2005, and it is actually premised on the ancestral model law international arbitration, with the few amendments that like Phillips has just mentioned earlier on. We have bring Malaysia to same position as the 2006 of the ancestral version. Now, the topic for discussion today is pro-arbitration ancillary legislation. And broadly, I'm going to talk about 2 things. One, I'm going to talk about the Arbitration Act 2005 with the 3 amendments that has been brought to date. That's number 1. And 2, I'm going to talk about what I think Robert Roda has also mentioned earlier this morning, liberalization of the practice day. Non-lawyers in Malaysia can actually appear for parties in arbitration proceedings in Malaysia. That I'm going to deal with the amendment to the Legal Profession Act of 1976. I pause for a moment now and I go back to why I explained that there are 13 states in Malaysia, two in East Malaysia, Sabah and Sarawak, and 11 in West Malaysia. The reason I say that is that the Arbitration Act of 2005 would apply to all the 13 states, whole of Malaysia, both East and West Malaysia. The Legal Profession Act of 1976 governs the practice in West Malaysia, because Sabah and Sarawak, they have their own Sarawak Advocates Ordinance and Sabah Advocates Ordinance, so they are separate, different in that sense. Right. Now, first, I'll move on to the, Arbitration Act 2005. Arbitration Act 2005. Over the years since the Act came into force on 15th of March 2006, it has actually been amended 3 times. I'm not going to go through each amendment, but suffice for me to just broadly say what the position is at the moment, and I'm only going to highlight what are the main amendments which are, in a sense, pro-arbitration ancillary legislation. Now, the first 2 that I'm going to highlight is actually in the slides here, you see Section 11. Section 11 of the Arbitration Act currently provides the powers to court to grant interim measures, right? Now, the one that's not in the slides here, which I would also like to talk about, is Section 19 of the Act. Section 19 actually mirrors Section 11. Section 19 gives the powers to the arbitral tribunal to actually provide for interim measures. And new additions to the Act since the 2005 Act came into force was that there are also provisions in Section 19A, 19A to 19J essentially. Broadly, what has happened is that provisions have been given also to give the powers to the tribunal to order preliminary orders. Preliminary orders to ensure that interim measures are not frustrated. It's like if we go for an injunction in court, we can actually go for an ex parte injunction to prevent that injunction we obtain would be frustrated. So things like the interim measures as well as preliminary orders. And the provisions there also has actually set out what are the conditions to be satisfied before one would be granted an interim measures. Another provision that is of importance that I would like to highlight is actually in Section 19J. It's not been reproduced here, but Section 19J states very clearly now that the interim measures to be provided by the court can be given irrespective of whether the seat of arbitration is in Malaysia. So if you have got an arbitration not seated in Malaysia and perhaps the assets are in Malaysia, you can actually go to Malaysian courts and actually seek interim measure as well. That's been made very clearly. I mean, although in the past it has been obtained, but it's not been made so clearly as it had since the amendment being incorporated to the Arbitration Act. Right. Now, I've also touched upon these three sections here. Sections 37, 38, and 39 of the Arbitration Act are essentially, Section 37 essentially deals with challenges of arbitration awards. 38 and 39 talks about recognition and enforcement of arbitration awards. These provisions has now make it very, very restrictive for parties to be able to challenge an award, either by an active challenge by way of application to set aside, or by a passive challenge by way of resisting a recognition and enforcement. And I think the courts have applied this very strictly. So it is in Malaysia, with the amendment to the Act here, very, very difficult for a party to actually challenge an arbitration award or to resist the enforcement of an arbitration award. Now, a very interesting amendment to the Act is introduction of amendment to Section 33 of the Act, which is not provided for in the slides. But what has happened, a bit of background there in Section 33 is this. Prior to the amendment, Section 33 of our Arbitration Act, or say unfortunately, actually provides that the arbitrator can award pre-award interest. And Section 33 then was silent as to, let me repeat. Let me rephrase. Section 33, prior to the amendment, provides the arbitrator can grant post-award interest, but was silent in respect of pre-award interest. So what has happened was that in a particular matter, an award was obtained. The arbitrator actually granted both pre- and post-award interests without making reference to the powers that were given to the arbitrators under Section 33. I think a lot of arbitration practitioners would wonder, well, that's quite common. Surely when you submit yourself to arbitration, you would have the powers to actually grant a pre-award interest as well, because after all, it's a dead deal. And, but in Malaysia, what happens in the Civil Law Act is that Civil Law Act provides the powers to the court to award pre-judgment interest. So the argument that was tabled was that since the courts had to rely on Section 11 of Civil Law Act to award pre-award interest, there is no provision in the Arbitration Act to award pre-award interest to the parties. Therefore, the arbitrator is not seized of that jurisdiction unless the arbitrator was given powers by the parties to do so. This argument was taken in by the courts from all levels, High Court, Court of Appeal, and the Federal Court, which agreed with that argument and actually set aside the part of the award which contains the pre-award interest. That creates quite a big havoc in the arbitration community. What has happened was immediately the legislature was moved to amend Section 33, which now provides both pre-award as well as post-award interest. So powers to the arbitrator now is to award both. That was the interest. The case in point which led to this amendment was a case of Far East against what you call Majlis Ugama Islam. Now, the other provision that has been added on to our Arbitration Act is actually Section 41A and Section 41B. Essentially, these two sections provides now or states out very clearly the issue of confidentiality, which means that, as we all know, arbitration, a lot of parties want to go for arbitration because it's confidential, and you want to maintain that confidentiality. So what the Parliament has done is to actually include Section 141A and 41B, which deals with the production of disclosure of documents. It's been used in arbitration and very restrictive on that. And it also talks about any hearings in a court arising from an arbitration are supposed to be in closed doors. So it has now reinforced the importance of arbitration being confidential in nature. Those are broadly some of the amendments that has been put in place over the last few years in the Arbitration Act. Now, the next thing I'm going to talk about is the Legal Profession Act 1976. Now, Legal Profession Act 1976, there was a recent amendment. Now, the recent amendment was also geared towards promoting international arbitration, to promote the growth in the international arbitration sector and access to broad range of international legal services. Now, the notable sections in the Act was 36, 37, and 37A. Now, Section 36 of the Act essentially talks about a practice as an advocate, as a solicitor in Malaysia. And as I mentioned, LPA, Legal Profession Act, applies only to West Malaysia, so practice of an advocate and solicitor in West Malaysia. And Section 37 restricts that practice, so no authorized person shall be permitted to practice, and so on and so forth. Now, what has happened is that these sections have now, a new section has been included into the Legal Profession Act 1976, which is Section 37A. Now, Section 37A now specifically provides the non-applicability of Sections 36 and 37 to arbitration proceedings seated in Malaysia. So, in the past, there were certain limitations imposed upon foreign counsel in non-arbitration matters under Section 37(2)(b), right? And I'm also going to deal with a fly-in, fly-out exception. So perhaps let me move to the next slide. Now, Section 37A, I think I'll just go through Section 37A. Section 37A here now states that Section 36 and 37 shall not apply to, okay, A, any arbitrator lawfully acting in any arbitral proceedings, B, any person representing any party in arbitral proceedings, or C, any person giving advice, preparing documents, and rendering any other assistance in relation to arising out of arbitral proceedings, except for court proceedings arising out of arbitral proceedings. And in this section, arbitral proceedings means proceedings in arbitration which is governed by the Arbitration Act, or would have been governed by the Act had the seat of arbitration been in Malaysia. So that is what Section 37A, it sets up very clearly. So arbitrators who are non-advocate and solicitor in Malaysia actually can come into Malaysia and arbitrate without any restrictions. Party representatives, lawyers, and all that can actually come in without any restrictions insofar as arbitration is concerned. So that's been made very clear. Now, I've also had in the slide Section 36 and Section 37, but I do not think that it's necessary to go through that. Right. Now, this Section 37(2)(b) is the one that I've mentioned before, which is prior to the amendment, or rather prior to the addition of Section 37A, Section 37(2)(b) actually says that no authorized person to act as advocate and solicitor, but it says that subsection 2A shall not apply to a foreign lawyer who is duly authorized or registered to practice in a state territory of Malaysia and enters Malaysia to advise or consult with a client on matters pertaining to law not involving any aspect of Malaysian law, provided always that the accumulated period of stay of that foreign lawyer shall not exceed to 60 days in total in any one calendar year, and that immigration authorization for each period of stay shall have first been obtained. So that restrictions is restrictions to foreign lawyers. So foreign lawyers can actually still come to Malaysia and advise the clients on the law which doesn't involve Malaysian law, but there's a restriction as to the time there. But now, insofar as arbitration is concerned, this restriction doesn't apply to foreign lawyers anymore. Now, so I've spoken about this introduction of Section 37A, which opens the doors of Malaysia to foreign lawyers. And I drew the distinction between East Malaysia or West Malaysia and East Malaysia because this addition of Section 37A to the Legal Profession Act only applies to West Malaysia. Insofar as East Malaysia is concerned, now the freedom enjoyed by foreign counsel in arbitration may not necessarily apply to East Malaysia, because what happens was that in East Malaysia, the legislation that governs the practice of lawyers is a bit different, and the wordings are also slightly a bit different. This position was taken prior to amendment to Section 37A in the LPA. This position was taken in this case of Samsuri bin Baharudin and another, which went all the way to federal court. What has happened in this case was that it was a domestic arbitration. The parties, the claimant were represented by Sabah lawyers. The respondent was represented also by solicitors, Sabah solicitors, but have engaged a counsel which is from KL. And the claimant actually took an objection to the practice of the KL lawyer in that arbitration and went all the way up. In the first instance, High Court says, no, you're a KL lawyer, you can't practice in Sabah, so even though it's an arbitration, you can't represent the parties in Sabah unless you get ad hoc admission. Court of Appeal reversed that decision. It went all the way to the Federal Court reinstated the position to say that it's only reserved for Sabah practitioners. The position in Sarawak may be similar because their legislation is similar. Right. Now, after that has happened, I think what has happened was that the Arbitration Act, there was a new inclusion of Section 3A, which says that unless otherwise agreed by parties, a party to arbitral proceedings may be represented in the proceedings by any representative appointed by the party. It's arguably whether this provision in the Arbitration Act would cure that situation. It's not been tested, so we don't know yet. That's broadly what I want to say about this too. Just the next thing, nothing much for me to say about ancillary legislation reform, because what I think is that third-party funding, which is not been introduced in Malaysia, but it's maybe something that Malaysia can look into and see what Singapore and Hong Kong and the other jurisdictions have done insofar as that is concerned. My time's out. Thank you very much.
Thank you very much. With due apologies to Hefin, India had Brexit 72 years back. But, you know, except perhaps for arbitration, because we still keep on going to Singapore, to UK, and also to Hong Kong. So on that note, even though the model law was enacted into a domestic legislation in 1996, but there were too many issues, apart from the domestic profession being very closed, not allowing foreign lawyers or arbitrators to come and do arbitration in India. There were further miseries, I will say, piled up by the interpretation of law by courts, including Supreme Court. So to the effort, the real effort to make India more arbitration friendly and international arbitration friendly was made through the amendments brought in 1996 Act in 2015. Now, earlier there was a confusion because part 1 looked like relating only to the domestic arbitration, and part 2, where, you know, enforcement of Geneva Convention, New York Convention, and all were dealt with, was international arbitration. So a long time there was uncertainty whether interim measures under Section 9 will be applicable to international arbitration. So that was set right by making Section 9 you know, applicable to international arbitrations as well. And, but still, you know, Section 9 in India is little differently worded from the model law, and one of the issues which arose from it was an international arbitration seated in India, was the term that an interim measure could be invoked before or during or just before the arbitration award is enforced. So the case which I dealt with was where the government went to enforce the award when the award was against it, seeking a restraint on release of performance bank guarantee. So the single judge of Delhi High Court said that, yes, given the wording that a party, it can be the losing party also, till the award is enforced. But then the division bench in appeal reversed that, and now it is still pending, though we got the you know, bank guarantee out in the meanwhile. So Section 9 now is specifically, applied to international arbitrations. Section 2 has been amended to give a clear-cut definition of what is international arbitration, and also to restrict any challenge, whether Indian-seated or foreign-seated arbitration, only to the high courts. Because otherwise, India being a federal union of federating states, we had various high courts with various original jurisdiction, civil jurisdiction and all, and even a huge international award could go before a district court in a remote corner. So that has been set right. And that has been coupled with establishment of Commercial Courts Act 2016, which under Section 10 has mandated that all the arbitration challenges or related proceedings will go before the commercial division of the High Court, and especially for international arbitration, it is only the High Court and no other courts before which these will go. Now, Section 34 added something for the domestic arbitration, that when an award has an patent illegality on the face of it. So that was introduced as an additional, ground for challenging a domestic award. But the other thing which was troubling was the definition of public policy. So public policy was redefined in very narrow terms, and it was introduced as fundamental policy of Indian law, which means, just some dissonance or something is not sufficient to strike down or refuse to execute an international award. So that is an important change as well. Now, 2019, we had, apart from that, various timelines were introduced. Like, for international arbitration, the only appointing authority is the Supreme Court, and any application filed under Section 11 is to be disposed of within 60 days. And then timelines for for India-seated international arbitration and domestic arbitration was made to be within 12 months of appointment of arbitrator, and any extension could only be, either on discretion of the court or consent of parties, and if you go to court, it has to be disposed of within 60 days as well. So a lot of expedition has been sought to be brought in. Now, 2019, another set of amendments has come in place in the Arbitration Act, and it is that, India has been mostly a jurisdiction of ad hoc arbitrations, and we did not have many institutions. So now, 2019 amendments' primary focus is to institutionalize arbitration in India by establishing Indian Council of Arbitration. It is in the works still. The act was brought into force in August 9, 2019, but then there was a government change, and the council has not, as such, been put in place. The rules have not been framed, but they should be coming soon. But one grievance which, the arbitration community and business community has is the extended role of the government and courts in such council, because, our view is that arbitration should be farthest from the government and the courts. So though it's a progressive measure in as much as it tries to institutionalize arbitration, but it is retrograde at the same time, as the composition of the council is supposed to be headed by a former judge of Supreme Court or High Court, and then two government nominees, of course, independent individuals, arbitrators, and all are also going to be there. But, the very fact that the government has a role and the courts have a role, we are looking at it as a big problem. Then, as the Advocates Act has not been amended, it remains so. So it is only through interpretation that the Supreme Court in 2018 judgment in A.K. Balaji's case has interpreted practice of law. And by interpreting practice of law, it has said that the cases where arbitrators come in to arbitrate or the councils come to assist the parties on foreign law cannot be held to be practice of law unless until it is so continuous that a person is supposed to be setting up a practice in India. So, but the Supreme Court has left it to the Bar Council and the government to make more defining rules concerning this, which have not been put in place as yet, but that to the extent that arbitrators can come and arbitrate in India and councils can appear, that uncertainty has gone. And there is no hard and fast rule for having a work permit. You can come under a business visa to India to act as an arbitrator because it is not considered as an employment. And if it is regular, then of course it is not permitted otherwise. The last thing which I'll discuss briefly is that the Brics, as the chair had said, is coming up with a network of arbitration institutions. Russia has established one in Moscow, New Delhi, and Johannesburg, and Brazil is designating one. We have finalized most of the framework in our meeting in October 2019 in Rio, and I think by the end of this year or next year, the Brics arbitration network will be fully functional. And the highlight of it is that, you know, it is one of the first kind of very deeply collaborating network of institutions. And to add to it, we are also proposing to set up something called IDRIB, which is International Dispute Institution for Emerging Economies and BRICS, primarily targeted at capacity building. The last thing which, you know, diverging from this topic, I like to say is that if we want to build capacities, one effort which has to be there, that common law, and English language remains a common link almost throughout the commercial arbitration world. But promotion of use of very simple English and not too difficult legalistic English is, I think, the way forward to expand the pie of arbitration. So, you know, a repository of agreements, templates which are in very simple, short sentences, uncomplicated English is what will make arbitration thrive much more. So that is another ancillary because, you know, most of the parties who do not speak English as a first language, they are not going to sleep with their lawyers or inhabit with their lawyers to understand the contract they have signed, because they are the ones who have to carry out the obligations in the agreements. So the basic ancillary requirement, if international arbitration is to thrive, is use of very simple English. Thank you very much.
Thank you. I would like to speak about arbitration in Thailand from Thailand perspective. I know that, I mean, I'm only the panel speaker who come from a different system, legal system, because most of the speakers here come from basically a common law jurisdiction. And Thailand has adopted a civil law system, so you won't be surprised that, you know, basically Thailand may be slightly different from other common law jurisdiction. I think Thailand is a member of the New York Convention. I think most of you probably know. And the Thai Arbitration Act was based on Ausitong model law. And Thai Supreme Court confirmed that that's a good news. Recently, Thai Supreme Court confirmed that Thailand adopted this Ausitong model law. So the interpretation should follow whatever the interpretation adopt by the auxiliary modern law country. That's a good news in connection with the seat of arbitration. Otherwise, there have been a lot of confusion concerning the revocation award made outside Thailand. They tried to revoke cancel the award in Thailand using Thai court as a venue. Even though Thailand has adopted auxiliary modern law, unfortunately Thailand still did not really pass or enact any ancillary legislation to directly or indirectly support the attractive of Thailand as a good venue of arbitration in the same manner as, London, Singapore, or Hong Kong. To work as a foreign arbitrator, in Thailand, a foreign arbitrator still require work permit and or work visa. I will mention later on how Thailand tried to make, Thailand as a good venue of arbitration, but still, I think it still is not sufficient. To give you some background, Thai law requires all foreigners who want to work in Thailand to obtain a work permit before you come into Thailand. You need to obtain a non-immigration visa and then apply to a work permit later on. And they got a list of occupation where foreigners cannot perform in Thailand. And basically in the past, arbitrations, including international arbitration, is one of them. And legal or litigation service are still prohibited occupation. So basically, the foreign lawyer cannot litigate in Thailand unless, the dispute is not governed by Thai law, and there's no need to enforce in Thailand. Basically, foreign lawyer can participate in international arbitration, provided it's governed by foreign law or something like that. Unfortunately, in the year of 2000, concerning the arbitration, there was an amendment was introduced to allow foreigners to act as arbitrator in Thailand. But still, you still require a work permit or a visa before you start working as a foreign arbitrator in Thailand. I think for the work permit requirement, basically, because of this work permit and visa requirement, most of, the party doesn't want to choose Thailand as a venue for arbitration because it's still quite burdensome. You need to apply a non-immigration visa, and then after you come in Thailand, you still need to apply a work permit before you can start working. And sometimes I experience situation whereby, the process is not complete yet on the date of hearing, and we have to basically move the venue of hearing to Singapore or somewhere, or have the video conference whereby the arbitrator had to be sitting in Singapore, and they got a video conference, in arbitration. It's happened from time to time because even though the concerned government agency say that they would try to accommodate, still, it's not very easy, and the procedure are still cumbersome. So, recently, in the year of 2019, in April, there was an amendment to the Thai Arbitration Act to make it basically easier to obtain a work permit to work as a foreign arbitrator in Thailand. Under the Arbitration Act, basically the party are allowed to act as foreign arbitrators conducted by, in Thailand. And if the proceeding or the hearing would be conducted by Thai Arbitration Center, THAC, or Thai Arbitration Institute like TAI, basically this agency would support you by issue a certificate to support your work permit application. And what based on the inquiry I have made, the concerned officer said, if you obtain a certificate from one of this agency, you should obtain a work permit within 1 day or immediately. So I hope that this will be implemented in practice. So just to be clear, I think the benefit under this amended Thai Arbitration Act is not limited to the arbitration conduct under the THAC or TAI rules. It could apply to IEC rules and apply to ad hoc arbitration also. So I hope that, that with this recent amendment, the foreign arbitrator would be encouraged to use Thailand as a venue of arbitration. And I hope that the work permit, even though in theory still required, it would not be really burdensome anymore. So basically, I was told that basically that under this new procedure under the amendment Thai Arbitration Act, basically all the officer at the THAC or TAC, they would really support you. If you need to do any arbitration in Thailand, they would have basically an officer on standby to provide any support that you need. Alternatively, I think work permits requirement to me, even though I'm a Thai, I didn't feel that it's burdensome. So recently, the Thai government tried to support new industry, including this profession, arbitration in Thailand. So the Office of the Board Investment, they issue a special announcement to support arbitration in Thailand. And basically, they would issue something so-called smart visa, whereby you would no longer require work permit to work in Thailand, but you need to obtain a smart visa. And the BOI would provide, they got us one-stop service centers. Basically, you need to, before you come to Thailand, you probably need to contact, the Thai embassy or Thai consular overseas, and ask them to say that you need a smart visa to work as a foreign arbitrator in Thailand. That probably you don't need to go to a work permit anyway. And under the regulation of the board investment, basically you can start working immediately despite the fact that, the process may not be actually complete everything. Basically. And this smart visa program, it's very, to me, it's attractive because it lasts for 4 years. And your spouse and children can work also in Thailand, provided your children is above 18. So to me, it's quite generous, and you don't have to, report every 90 days like the normal work permit. You just report on a daily basis. So you can see that this smart visa, in a way, it's just, I think basically understand the Thai government need very much to support arbitration in Thailand because it helps Thai economy. That's why basically you don't need work permit anymore. You call it smart visa. Actually, I'm not quite sure you go into the UK, I need a visa still. That's why you don't need a work permit, but I still need a visa, right? For Singapore and Malaysia, I don't need one. Hong Kong also. India, I still need one also. So even though you need a smart visa, actually it's similar to the UK, right? The visa thing is basically reciprocate between each country, right? So the smart visa, I hope that would help everything to solve all the issue, and the smart visa basically would support not only on the arbitrator, support your spouse, your students, transcribers, your supporter, which I think include, the tribunals category also. That's how I interpret it. So you have, the tribunals category, right? Coming to Thailand to work, you may need to bring your transcriber also. So please try to see whether the smart visa program would help you to really use Thailand as a venue for arbitrations. However, despite all this, good recent development, I think there's still a lot of area improvement from my point of view. The first area, to me, I think Thailand should, amend the law to get rid of the work permit requirement. Should be similar as Singapore, right? And Malaysia, whereby, you don't need a visa among ASEAN members or something. At least starting with ASEAN country first, you don't need a visa. And you basically, I'm not quite sure, Thailand, basically the Thai lawyer, you may have heard from Professor Chaiwat that, the legal profession is still quite concerned that the foreign arbitrator would take some work away from them. So, but I think similar to Singapore, I'm not quite sure Malaysia also. They still need a Thai lawyer to help them anyway. And maybe the Thai legal profession perceive arbitration in a way that to me is not absolutely appropriate, because arbitration service you probably spend just 1 week or 2 weeks in Thailand. It's not like other profession where you work as CEO for 1 whole year or 3 years. So I mean they have to change this perception of being an arbitrator. It's just a 1 week or 2 weeks, right? Being in Thailand, not for the whole year or 2 years. Similar to other profession that they are concerned, like becoming a CEO of a major, right, a big company. This is an area I think they should adopt. I mean, get rid of the work permit, the development, and just use the concept of smart visa. And the period should be shortened. Right now, I heard it should be about 30 days. To me, it should not take that more than 1 or 2 weeks, right? Because to me, it's the policy is already there, right? It's just a bureaucracy system that you need to really, right? You click in, that you apply, and you provide support document, right? It should be automatic. The second area that I think there should be ancillary to support Thailand as a venue for arbitration is a power of the arbitrator to issue interim measures or interim court order. Right now, I have been asked from time to time, they got an award, and then basically the losing party, they want to really try to dispose their assets that they have in Thailand. Under Thai Arbitration Act, I mean, you still have to go to court to apply for an order for interim measures or interim order, which to me sometimes, I mean, the Thai court may not be willing to entertain because they think that you are using the Thai facility, right? Without paying, I mean, proper legal fee, like normal litigation. So I'm not quite sure attitude is still within the discussion of Thai court, but I'm still concerned. I mean, I used to be in the judicial profession for 10 years, and you can understand sometimes they got a lot of workload already. And you go on Friday evening, it's difficult, I can guarantee you. They got other things on urgent on their desk, and they may not entertain you. And I think the another area is this area about interim measure. I think that the Thai Arbitration Act should be amended to allow arbitrators to issue interim court order and to have the legal status as court order similar in Singapore. That's what I heard. Singapore adopt that legal position whereby interim order issued by arbitrator have a similar legal status as court order. To me, that's quite a positive development, and I hope Thailand would follow. I know that right now, it's a good news that right now Thailand signed, Chulalongkorn University signed MOU with the SIAC to provide a training to Thai law students with SIAC. Because to me, I mean, Singapore is close to Thailand, and I used to act as arbitrator there. It's quite friendly, to be frank, as Maxwell Center. I quite admire, and I think each year a lot of some Thai just went there just to hear and exchange views, and to me that's a positive development. Even in this seminar and conference, I would encourage, I'm not quite sure you invite judges to attend, I would encourage to invite judges from the Thai court to attend so that, I mean, they really get a feeling, because Thailand, Thai judges sometimes are quite jealous of their jurisdiction. Like arbitration agreement, you have to draft carefully. Otherwise, they said you have still to go to Thai court. You have to draft carefully. I mean, Thailand still adopt very narrow interpretation of arbitration agreement. Another area that I think Thailand should further develop is enforcement of arbitration award foreign. That one right now, basically, I mean, the procedure is still cumbersome to me, like how you serve, the summon to the other party, and the court fee should not be too much, because they spend already a lot, in arbitration, and then you have to pay a lot of court fees, and the translation requirements sometimes should not be too much. They should be required to translate a certain part, right? I mean, the essence of the award. Don't need to translate the whole thing, because sometimes the cost of translation is a lot, I think. And apart from that, I mean, the procedure should be like a summary judgment procedure. You should have a limit of 6 months. I heard Singapore is short, but still sometimes I feel that it's not so short as, you know, as advocate, because you see in a backlog of case in Singapore also. Because Thailand, I think I would advocate that it should be a 6-month period. So it should be a fast track for arbitration-related proceeding. And then in turn up, you know, a service of someone, it should be by registered mail, you know, by DHL, anything that should be acceptable. The next one that I think that Thailand arbitration is still, I mean, not aligned with Singapore or ICC or London is the arbitration fees. Sometimes the scale is too low. That's why foreign arbitrator doesn't want to accept, you know, arbitration under THAC or TAI rule. It's so low. Even TAI, I heard lately is still that basically is still less than 50%, 15% of arbitration fee in the scale of SIAC. That make it unattractive. I have been approached to act as arbitrator on a few, but I have to turn down because I can accept 1 or 2 a year because the fee is too low. And this encourage foreign arbitrator for accepting being an arbitrator in Thailand. I'm not quite sure Mr. Smith, you know, Victor can tenderly testify to that. Basically, he has been trying to help Thailand to promote, you know, arbitration in Thailand also. I think I would like to mention about something that basically Sweden mentioned about the subpoena. I think Thai Arbitration Act allows subpoena, okay. And then the third-party funding is still not really allowed. And I think recently public policy, I would encourage you that you may have heard good news that basically regarding the case of Hopewell, the Thai Supreme Administrative Court, I mean, endorsed the award to infer a Hopewell against the Thai government. So this should be a positive news to show that, I mean, public policy ground of revocation is not that easy, and the Thai court will adopt. Sorry, thank you, Professor Yang. I was warned my time is limited. Thank you.
I noticed that the time for lunch is up, and I don't want to hold you back. We start 5 to 10 minutes late in our session, so I'm not sure if I may exercise my power. And I noticed somebody, and I expect somebody from Hong Kong to say something about Ying's interim measure arrangement with the mainland. So with that, if I may, please invite.
Thank you very much, Philip. And thank you very much to the panelists for their very informative presentations. I have a comment and then I have a question. My comment is on the comment of Swee Yen with respect to the interim measures arrangement and the question that we've sometimes heard as to whether or not that will mean that Chinese parties will not opt for Hong Kong. And I would like to offer 3 observations when we're thinking about that answer. The first is that we know anecdotally that when Chinese parties are in deals with foreign parties, very often the first proposal with respect to the seat is a seat in mainland China, which would automatically mean that that Chinese party is then, the interim measures from the mainland Chinese courts are available in respect of that Chinese party. My second observation is this. Before the special arrangement with respect to the reinforcement of foreign awards between mainland China and Hong Kong, there was some doubt as to whether or not awards that were coming out of Hong Kong were enforceable against mainland Chinese parties. The arrangement was then concluded, and that put that question to rest. Since that time, 2000, there have been many occasions on which mainland Chinese parties have opted for Hong Kong as a seat, notwithstanding that that meant that certainly their awards were enforceable. So I don't know that this new arrangement will necessarily mean that Chinese parties will not opt for Hong Kong, just as that did not deter them back in 2000. I think that's also manifested by our case statistics, because year on year at HKIAC, in cases involving foreign parties, we have approximately 40% of cases that involve mainland Chinese parties. My final comment in that respect is what we observe coming out of the application and the implementation of the arrangement to date. HKIAC has received 13 applications under the arrangement. It might be interesting for this audience to know that of the applicants under the arrangement, almost half were mainland Chinese parties. Also, with respect to the respondents under the applications, almost half were non-Chinese parties. So I think there are many more layers to this question than one might first think. And really we should think about it as whether a party has interest in assets on the mainland or evidence on the mainland or conduct on the mainland. That's the better way to think about it, I think. And I think that it is a game changer. And I think that as a legal advisor, if your party has interest in assets, conduct, or evidence on the mainland, then it is a no-brainer to think about Hong Kong as a seat if, for one reason or another, the mainland Chinese seat is not what the parties are opting for. Those are my comments. I have a question with respect to the Singaporean courts. I note that Swee Yen alluded to the case of Sainem in Laos. And in that case, what happened was a tribunal had made a jurisdictional finding which was purely based on international law. It concerned solely the interpretation of the PRC Laos Treaty and whether or not that extended to Macau. It also concerned the interpretation of the treaty with respect to the operation of a fork and road clause. Now, those questions were carefully considered and determined by a tribunal made up of international law specialists. When that award was challenged at the Singaporean courts, the first instance judge set aside the award in full. My question to Swee Yen, and I know that that is not the only investment treaty case where the Singaporean courts have set aside the jurisdictional findings in full. My question to Swee Yen is, do you think that the Singaporean courts are showing sufficient deference to international tribunals when they are being called upon to exercise their jurisdiction, their competence to determine jurisdictional findings?
Actually, thank you very much, Sarah, for sharing those statistics, because I think where I landed was that, when we look at whether it's a game changer, different people have different perspectives, and I think the statistics that you have shared actually shows that it is a game changer in the sense that it actually is enhancing Hong Kong as a choice of a seat for disputes which have a PRC-related party or which has some PRC angle, like you mentioned. I do agree, particularly if there's evidence or assets within PRC, certainly this would be something that you will be advising your clients on. Then picking up on the question on the various investment cases that have come before the Singapore courts. You are correct in your observations that the Singapore courts have at times set aside the award and at times upheld the award. I think the two cases that have actually gone all the way to the Court of Appeal, if you look at the score sheet, and there's only been 2 international investment cases, one has been upheld because that Sanum decision, the Singapore Court of Appeal, disagreed with the High Court. And the Lesotho decision, the Singapore Court of Appeal had actually set aside the award on jurisdictional grounds. I think what it says about the Singapore courts is that when they actually look at the jurisdictional appeal, they do adopt the approach which generally is adopted amongst most pro-arbitration jurisdiction, which is a de novo approach when they look at the question of jurisdiction. When they look at the question of jurisdiction, because it is so fundamental to arbitration, they actually do relook the entire question. When they do relook the entire question, and it comes to the question of jurisdiction, that does mean that, to a certain extent, while they may analyze and they may review the tribunal's ruling, what is important for them is not to look at it in any particular way as, I think, signaling whether the tribunal has jurisdiction or not. Because if they perform their task in any way, which suggests that they are not adopting a de novo approach, that actually would be inconsistent with international arbitration and the practice of pro-arbitration jurisprudence and the position under the model law. So when the question becomes, when you set aside an award, does this naturally mean that you do not show sufficient deference to the arbitral tribunal? I think my answer is no. Again, like what you said, there are various layers to that. I think when the Singapore courts look at a tribunal ruling on jurisdictional appeal, on the point of jurisdiction, or whether is it a merits and there's a setting aside case, the Singapore courts would actually carefully analyze the decision. They would analyze the decision, they would look at what were the various things which the tribunal considered, and you can see in all the judgments, they actually did go through this analysis. But what they will not do is they will not be beholden to the tribunal's ruling, because the law tells them you are not supposed to be beholden or not supposed to show to a certain extent any deference, because you're supposed to look at it afresh. So if you ask me, I think the approach that's been taken by the Singapore courts, because you shouldn't be looking at the outcome, but you should be looking at how they're actually looking at arbitral tribunal ruling, I think is actually a pro-arbitration and consistent with international arbitration jurisprudence.
I noticed the time, but I think unless there is any burning question or burning point from my Hong Kong colleagues with regard to the game changer or other burning question to the members of the tribunal, I have to call the session to an end. Do I see any hands? No, if not, I think I have to call the session to a close. Yes. Oh, yes, Mr. Kumar.
See, the only thing on the, this special listing in Hong Kong as a game changer is whether, the whole thing of Hong Kong having been a separate jurisdiction, neutral jurisdiction, whether this measure, by making it a special jurisdiction more aligned with, Chinese mainland, that it has been conferred this benefit, also brings in some way, some notions of neutrality being diluted. Because, Hong Kong's attribute was, it was part of, special administrative region, but very, very neutral. Whether it shows, that neutrality's perception has gone down a bit because of this. It's a nuance.
If I may say it before Mr. Xu Ying, I thought that neutrality is more in favor of foreign parties because they can get a very certain and assured remedy towards Chinese parties. In that sense, I don't think Hong Kong is being affected when it comes to neutrality in the international context. Would you agree?
Yeah, I do agree. Yeah.
With that, I think I really have to bring the session to a close. And I invite all of you to thank all my learned speakers in the usual manner. Thank you.
Thank you so much. Thank you for the informative talk. And right now, ladies and gentlemen, we prepare you all with a special meal right there in this adjacent room. And we will come back for the next session that will start once again at 1:50. Please be on time. Thank you.